Let's take a look at the Constitution and affirmative action. More frequently, challenges to the use of preferences by public employers allege violations of the U.S. Constitution. In constitutional cases, courts subject the use of racial preference in affirmative action plans to strict scrutiny, the most stringent form of judicial review of government action. To survive a constitutional challenge to its affirmative action plan that uses racial preference, a public employer must show that the plan serves a compelling governmental interest and that the measures employed are narrowly tailored. Put differently, the plan must serve a very important public purpose and harm the interests of non-preferred persons no more than absolutely necessary. One compelling governmental interest is remedying the effects of prior discrimination by a particular public employer. Statistical disparities showing underutilization do not suffice as a constitutional justification for affirmative action, absent evidence that the public employer's discriminatory acts produced those disparities. A public employer that engages in affirmative action pursuant to a valid court order issued after a finding of discrimination would have a compelling interest in complying with the terms of that order. Courts scrutinize whether consent decrees actually require the specific actions taken in their name and whether they already outlived their usefulness at the time those actions were taken. In several cases, the Supreme Court has endorsed the view that non-remedial purpose, student body diversity, can be a compelling governmental interest that justifies the use of race in university admissions. However, the court has not provided any indication that this diversity rationale extends to the workforces of public employers. To be constitutional, racial preferences must also be narrowly tailored. This requirement is more likely to be met if racial preferences are not overly burdensome. Race-neutral methods were tried and proved inadequate. The preferences do not amount to rigid quotas, and their use is temporary. To say that race-conscious affirmative action plans can sometimes withstand the strict scrutiny required under the Constitution does not mean that states are required to use such measures. In fact, public employers in several states are prohibited from extending preferences in public employment, education, and contracting based on race and other protected class statuses.